And my background is from academia, and I will first explain to you why and how I did come to this major topic. Obviously, it's of interest for every practicing lawyer, but obviously also for all of us dealing and very much worried about defense rights and cooperation at the international level. And so I realized that there was a gap precisely in cross-border cases with regard to the protection of lawyer-client privilege, because the scope was quite different. And during a World Conference on of the International Academy of Comparative Law in 2018, which took place in Fukuoka in Japan, so I had the privilege to be reporter of the section on criminal procedure dealing with lawyer-client privilege at a global level. So at that time, I'm not recalling all our findings that in this report, which we published, but we managed to cover not only European Union countries, but also Asian countries and American countries. So, and out of that study, we really got the idea that we should be working further into creating supranational framework at the European Union level to enhance the protection of lawyer-client privilege, specifically in a digital setting, because with regard to certain investigative measures, there is clearly an insufficient protection of the communications between lawyer and client. And second, it should be clarified what is the scope of the protection. So what communications, what information, what files, what electronic exchange of mails are protected or not under the lawyer-client privilege. So I will try to give you this afternoon a short overview of these findings, and obviously not tackling all of the issues, but those where I think we should focus because they are the most problematic ones. And I must, if not shed light or provide solutions for them, at least rethink and give you some food for thought or further thought, and also to help us in trying to convince the Commission, the European Union, that something has to be done in order to protect these confidential communications at the supranational level. So I'm sure that during yesterday's presentations, you already went through the concept and the aim of the lawyer-client privilege, lawyer's professional secrecy, or lawyer-client confidentiality. So these are the terms that are used absolutely as exchangeable. And obviously, the main aim is to protect the trust between lawyer and client. Why? Because this is essential and crucial. I'm not saying anything new in this regard, to provide an adequate legal defense within the criminal procedure. So, and this has been very well, and I just quoted here, in several judgments of the European Court of Human Rights. I quote here André Nader of 2008 versus France, and Xavier Silveira also versus France in 2010. And the secrecy encourages open and honest communication between the lawyer and the client, and this communication needs to be protected by the Convention as an essential warranty of the right of defense. So this is pretty clear for all of us, and it has been underlined in the sense that it's not only to facilitate this open and trustworthy and honest communication, but also that no one hears this communication. And it's not only the obligation of the lawyer to provide secrecy and ensure this secrecy, but also that the state has to ensure that these communications are not accessed by third parties. And there is where we find absolutely more problematic issues. And the comparative level, I will address certain outliers within the European Union, but I will also try to point out some marking differences between the common law countries, so mainly some differences between British, US, and the European Union, and also within the European Union member states. So sometimes I think it has been kind of neglected, stating, okay, this is provided in all countries. So far as I've been able to reach out, I would say 28 countries all over the world were studied by us. And obviously in the legal framework, it's established as an obligation of professional secrecy. This is not new. It dates back from the 18th century, at least. And how to protect this obligation to secrecy, it has been compared in the United States as the religious professional secrecy of priests, or confession secrecy in the canon law. But the issue is not only the obligation, which is sanctioned in all countries I've been going through by as a criminal offense to reveal these secrets, but the interference that comes from others and the scope of the waiver. Those are the problematic areas. So we are clear, and it's pretty clear that this is an instrumental right to the defense and has to be taken really very seriously, because as they put it in the American doctrine, it's really a gold mine for investigators to get into or interfere into the communications between lawyer and client. So there might not be necessary to undertake other investigative measures, because just looking and hearing what they communicate among themselves, you get not the evidence as such, but all the leads that might be important in order to either gain and convince the defendant to come to a plea agreement, or just obtain the defense if we're going to trial. And we will see that these interferences in most countries are not leading to an exclusionary rule of evidence. And this is a major problem too. So I will be addressing the two aspects, the obligation of the lawyer. There are two aspects. The obligation of the lawyer to keep the secret, which we would say the horizontal obligation, and obviously the other aspect of the lawyer-client privilege, which is the protection of these communications against interference by third persons, mainly by the state. So I'm not dealing with the first aspect, which is quite, I would say, harmonized. In every country, there's the obligation. The consequences might be different, but in all of them, there is a disbarment. And second, if there is no crime fraud exception, or there is no involvement of the professional services of the lawyer involved, in which two cases there is the exception admitted that the lawyer can disclose secret information and communications just for his own defense, or to prevent a serious crime. And I will mainly because I think this is where the major risks are, focus more in the vertical protection, so against the state and against interferences. This is I'm not doing here some kind of publicity of the book we did, but this is where we published the study undertaken back in 2018, and coordinated together with Stephen Thayman from the US and Veronica Lim from Switzerland. And if you are interested, I can share with you some chapters or some more information. And when we talk about interference of the state into the lawyer-client confidentiality, the first question that arises is what are the communications that are privileged, and so they should be kept confidential, and which communications between lawyer and client, if they talk about the arrangement in selling real estate, or putting up or building up a corporation, so which requires legal advice and might entail some problems from the point of view of the criminal law? Or are we talking only about communications when it comes to defense strategy within an already ongoing criminal procedure? And in that sense, we find a really variegated panoply of solutions from those countries that really cover and provide protection for any kind of communications to, we will see, for example, the British and the anti-money laundering and financing of terrorism prevention directives, whereas at the European Union level, you know that only certain communications are privileged and are to be kept secret. And on the other side, even the lawyer has the obligation to report about that. The third point I will try to address is what happens when a lawyer is subpoenaed. So it's summoned to testify as a witness, in which cases he or she, they can refuse to testify, which is very much connected with the previous point I addressed in what kind of communications should they not be, is it prohibited to summon a lawyer? Only in certain cases, only if he or she is acting as legal assistance within a procedure, or in general. There's no possibility to make them testify in one country. And finally, the issue which is problematic is what is the position of the in-house lawyers with respect to protection of legal persons when legal persons are facing a criminal procedure as defendant in those countries where a corporate criminal liability is regulated. So you will see, I'm not tackling all of those problems related on the regulation in this and the other country, but rather pointing up important differences that need to be addressed at the supranational level, which is precisely the role of lawyers and the protection of the lawyer-client privilege. When summoned as witness, when with regards to the in-house lawyers in corporate criminal liability, and trying to find out which are the communications that are really protected. So starting with the lawyer as witness. And I want here to recall a very salient case through the case law of the European Court of Human Rights, which I was not asked to address today precisely, but we come to the practice of the national states. And when it comes to the summoning of a lawyer, as I put there on the slide, most countries have a broad prohibition to summon a lawyer as witness within the European Union. However, not in the US, where it is frequent to subpoena a lawyer. And if the lawyer appears before the grand jury, obviously he has to resign as his position of defense lawyer, obviously because there would be a conflict of interest. But in that case, being subpoenaed and appearing before the grand jury, in that case, the lawyer is not liable to breach of secrecy or professional secrecy and would not be made criminally liable himself. So in most countries, when it comes to summon a lawyer, and I'm talking now right now on the European Union level, they have obviously the obligation to refuse to testify, invoking the lawyer-client privilege, but they can obviously appear in court when they summon to do it if the client allows them to do so. So in Europe, the owner of the lawyer-client privilege, of the right to confidentiality, lies with the client. So with the client, And if the client really renounces, waives his right to confidentiality, the lawyer then would be obliged to appear in court and testify. There is a very interesting case, and I wanted to present it to you this afternoon, which is the Klaus Müller versus Germany. My German colleagues are sure very much knowledgeable about this case. And this case deals with a German lawyer, Klaus Müller, who was advising, so to say, the direct out of the company lawyer, and so the corporate lawyer of a company, and the company is being sued. I think I remember for kind of fraud bankruptcy. And Klaus Müller was advising them for almost 20 years as an independent law firm. And once the corporation, the company, enters into bankruptcy, the new administrators are appointed, and a new board of directors is appointed. And this new board of directors and the new administrator, during the proceedings, the criminal proceedings, want to summon Klaus Müller as witness, and he is really summoned. He invokes his refusal to testify, stating that he has been advising this company, and so he must keep the lawyer-client privilege. The company itself states that they waive his right to lawyer-client privilege. And the main question that is to be discussed here is, who can waive the right to lawyer-client privilege in cases of corporations? The previous administrators, board of directors, with whom the lawyer was really in close contact, exchanging confidential information, or the right to waive lies with the company as long as the board of directors and the administrators represent the company and the current representation waive these rights. And this was a very much debated issue, because at the end, there were different approaches at the national level in Germany. Different courts considered that mainly as long as the corporation is represented by the new board owns the right to waive the lawyer-client privilege, and so Klaus Müller should be summoned, which was adequate, and should appear in court to testify. Klaus Müller nevertheless stated that this was against his oath on professional duties, and for that non-appearance in court, he was sanctioned at an administrative level, and was also a warning to be disbarred. At the end, the court stated that it was not against the convention to sanction Klaus Müller for non-appearance in court. So, but the court didn't go deeper into who has the right to waive the lawyer-client privilege. So I think this case shows how important it is to identify who is really the owner of the lawyer-client privilege. Obviously the defendant. Well, what happens if there are a plurality of defendants and all of them have communicated with the same lawyer? And second, important with regard to legal persons. The second point, we found a lot of diverse solutions is with regard to production orders. So mainly in economic crimes and where corporations, again, are involved. What happens with the documents that have been exchanging between lawyers and companies in order not only when a litigation has already started, we will see later, also with regard to internal investigations, but also with regard to other kind of advices regarding the legal strategy in certain investments, in certain acquisition and merger proceedings, and so forth. So what is clear, and it appears from a comparative point of view, in all countries, it's that instruments or proceeds of crime are not covered by lawyer-client privilege, which is very easy to say, but very difficult to identify in practice what is meant here by instruments or proceeds of crime. So when it came to physical instruments, it's pretty clear. The lawyer has to hand over to the investigation the weapon. That's pretty clear. But what happens with documents? If they are forged documents, if those documents represent and show the fraud that has been committed, those are proceeds of crime or instruments of the crime? Because if they were really forged, then they are part and evidence and proceeds of crime. But it is not easy in practice, not even for the lawyer, to differentiate, is this a forged document or not? So in practice, those documents that are really covered by lawyer-client privilege, precisely in economic crime prosecution, it's very difficult to differentiate if they are complying with this obligation, or they are really protecting this right to confidentiality of their communications. Talking to big law firms and dealing with really severe financial crimes and severe economic crimes, corporate crime, the issue is also related to one question which is very difficult to address, which is all the forensics that are being carried out, be it by KPMG or Grant Thornton or whatever, or Deloitte, when it comes to corporate criminal liability. The usual approach of the law firm that takes over the defense of an important, complex criminal case against a corporation, the usual approach is they provide these documents to either the forensics or to an auditing company. So the documents, the privileged communications, does this entail all the documents the client has provided to the law firm? And the law firm, in order to make an assessment if there's a crime and a conflict of interest or another type of fraud or corruption, is this, when the documents are handed over to the auditing companies or the forensic companies, also privileged? So the privilege extends not only to those documents that the law firm itself manages, or also to the auditing companies. And we see here, for example, the German example that covers right not to testify or right to keep the professional secrecy also for auditing companies, on auditors. But this is not the case. In this Zeugnisverweigerungsgesetz and Zeugnisverweigerungsrecht does not apply in other countries. So in practice, they really don't know how to approach when they are handing over all the files the client has provided to the law firm in order to undertake a defense. Because what we are seeing, for example, in my country, in Spain, is that being the law firm under a very strict protection and restrictive possibility, obviously, of search and seizure within the law firm, public prosecutors have, in some cases, just issued and requested the judge to issue a warrant to search and seizure of the documents held by the auditing company, which is kind of a subversion and circumvention of the lawyer-client privilege, because at the end, it's not easy to say, are these instruments and proceeds of crime, or is this communication and information and in form of written documents that needs to be handled by the law firm in order to prepare an adequate defense in these type of crimes. And when dealing also with the concept of what kind of documents the law firm and lawyers are under the lawyer-client privilege, those working in this area very well know the concept of work product. So work product is all the information and documents prepared by the lawyers in order to prepare the defense of a client, be it what they talk to a private detective or to the staff, or everything what is really preparatory work to establish a defense. Obviously in the States, where there is a broad discovery obligation, precisely in civil cases, work product can be absolutely enormous. Files and files, if not lorries full of, in the past, lorries full of paper. Right now, it's the main work, as you know, for economic crime lawyers in the States is undergoing discovery and search of computers, and IT personnel has more and more relevance in this area. So even we could think here also, and I leave the question, should this privilege be extended also to everyone dealing with the information with regard to the defense, not only auditors, but also IT persons. And to that end, the term of work product, which is broader than the lawyer-client privilege in the US, as I tell you, it does not only cover confidential communications, but everything, every paper prepared for the defense. And it is not clear. It is not clear if work product is protected within the European Union. What we see within the United States is that physical persons can invoke the Fifth Amendment, so right not to incriminate themselves, but legal persons do not enjoy these rights not to incriminate themselves. So this is very important when we are talking about production orders and the scope of the rights of defense of the legal persons. Why? Because we are now seeing that in criminal investigations against companies, they try not to provide any documents stating it is work product, so documents prepared for the defense, even if it's not dealt by an external law firm, and invoking the right not to incriminate themselves. While all this corporate criminal liability doctrine and theory and scheme, which has been kind of imported or taken over through a comparative translation or assimilation from the United States, we see that this right to refuse to produce and present to the investigators this work product does not apply to legal persons. So this is important to very much in need to recall that we need guidance in what is the communications, the documents that are really covered by the lawyer-client privilege. Work product in the broader sense as in the state, but then counterbalance with the non-possibility of invoking the right not to provide any information and not to incriminate oneself, or the other way around. In the European area, we find the only country I found that has a distinction between the different documents and files that are holding and are being held by the law firm, which are covered by the lawyer-client privilege and not. So, for example, in the UK, they differentiate between when they talk about protected material and between privileged which is absolutely not able to be searched and seized by the state, by any law enforcement. So this is privileged and cannot be accessed and cannot be disclosed, because it deals to confidential communications between lawyer and client, and is related to the defense. And then two other levels of protection, which is the documents that are, or files that are excluded, which might relate to the defense, but not confidential communications, and then other special material, which need to be protected, but at the lower level, which is, for example, communications with the staff, administrative communications, and there might be also included certain types of activities that are covered in the United States by the concept of work product. So what we see in the United Kingdom within this classification of three levels of protection of documents, privilege, excluded, and special material, we don't find it in other countries. So either they consider the whole files, all the computers and every kind of communications, mails, exchange between a client and the lawyer are completely protected. Nothing can be accessed, regardless the type of information it contains. And others that they say, okay, after the filtering, we access to all the information, but we exclude that type of communication that does not have to do with either the investigation, it's not evidence. So, and third, it's not privileged because it's not discussing the defense strategy in itself. And this different level of protection is causing really many problems, and I would say also abuses on the side of certain prosecutors and law enforcement, which are considered that they can access all the files and computers in the law firm, and then they will filter. But by doing this filter, they already have a look on what is privileged communications. I will come later back to the search of the computers. So we see up to now the problems with the subpoena, like in the Klaus Müller case, the problems of identifying what is a work product and what are the documents covered by the lawyer-client privilege. I only put here in these slides that we already have some guidance at the supranational level by lawyer-client privilege and corporate criminal liability. You perfectly know this very well-known benchmark case of Droit des Barreaux francophone of 2007 of the Court of Justice of the European Union, where it's not properly a criminal case, it's a competition case. And the idea was if the in-house lawyer is also covered by the lawyer-client privilege, so an in-house lawyer cannot be summoned to testify against the company or in proceedings related to the company. And the criterion followed by the court in this benchmark case was that as long as the in-house lawyer is not independent, but is an employee of the corporation, he or she has the duty to collaborate fairly in the crime prevention and also cooperate in the crime investigation. And this is repeated. The same approach is considered again in 2010. So reaffirmed by the Court of Justice in the also very well-known Akzo Nobel Chemicals Limited case, where the same criterion is adopted. Lawyers, in-house lawyers, are very much against this approach, and they consider and criticize it because they say just for being independent, so out of the company, and exteriorizing or outsourcing all the advice in order to protect this lawyer-client privilege is not an adequate criterion. The adequate criterion should be that the in-house lawyer is also protected, but not based on if he's employee or if it's an out of the house lawyer, but on the basis of the functions performed by this company lawyer. and not so much on his status as an employee. So to say, because in corporate criminal liability, the recent trend by every company who is under a corporate compliance program is to outsource the services of the legal advice, because this is the only way to protect the confidentiality of the communications between the client, so the company, and the lawyer. Otherwise, the in-house lawyer, if he or she undertakes the role of organizing the defense strategy for the company, since he or she is obliged to testify and is not in the position to invoke lawyer-client privilege, obviously no company will risk, which is seen again as a very, very strange or very strict approach to what the functions are of the in-house lawyer within the company. So if the company really appoints as a defense lawyer its own in-house lawyer, then the same lawyer-client privilege should apply. I will make only a very short comment on one of the issues that was very much discussed. My German colleague will surely point out on these issues, and the German Constitutional Court judgment on a search of offices carried out in Germany. And this judgment of July 6, 2018 of the German Verfassungsgericht was dealing with the search of offices of an international, a very big one, law firm, which is Jones Day. And the search was ordered in their premises in München, related to the Volkswagen diesel affair. And in this, during this search, what the law firm tried to invoke is the work product protection. So since they are American incorporation, an American law firm, they I think I'm not confused. I might be. I think they are American, not British. Sorry if I'm confusing you right now. They wanted to have applied the lawyer-client privilege according to the rules of their own incorporation. And however, the German Constitutional Court refused this and said that work production was not under privilege, and the rules in Germany should apply. This in a very rough way, just to summarize, because I'm sure that in the next presentation, my colleague will come and point on that. So this adds some of the problems that would be considered right now as very, very problematic at the European Union level with regard to lawyer-client privilege. The last point, which is very much discussed, and Holger absolutely has dealt with it, I'm sure, because there are several reports on the in position papers of the CJEU on the duty of secrecy and the exercise of functions and in the prevention of crime. So with regard to anti-money laundering or money laundering prevention acts and prevention of financing of terrorism, you know that since 2001, the European directive, it already imposes certain obligation to disclosure. This obligation to disclosure extends also to notaries, to real estate agents, and to lawyers since the directive in 2015, and are continued in the last directive of 2018 on money laundering prevention. So this has changed completely the landscape on the from the point of view of the lawyers, of the trust and confidential communication between lawyer and client. So because the lawyer will have a duty to report any kind of suspicious activity that falls within certain legal advice. I'm not saying in criminal defense is excluded, but sometimes it's not easy to differentiate. Is this criminal defense, or is this just a legal advice for corporate investment or for the acquisition of real estate. If it's on real estate, they have the obligation to report to the Financial Intelligence Unit at the national level. But complex cases, and as I was talking to several law firms, in these big firms that have already a huge anti-money laundering department, in order not to prevent the liability of law firms in making them accomplices to the crime of money laundering, they are obliging the law firms just to change their strategy towards the defense and their communications with their clients. First, don't communicate by email, because it might be I am on the obligation to report to the Financial Intelligence Unit on certain issues. And second, they really are very much worried, because in certain advice, in certain very complex operations, specifically in tax fraud or in tax strategy, it is not easy to differentiate what is advising on management and what is advising on preventing criminal liability. This is a major issue that needs to be addressed in order to give some guidance in the interpretation of the anti-money laundering direction and what is really covered by lawyer-client privilege, beyond obviously the communication in jail between a detained person and a lawyer, which is absolutely clear. But in advice to corporations and economic crime, this is by far more blurred and confusing. The last point I want to address is a search and seizure. Search and seizure in law firms. In law firms, the general requirement, obviously, as set out by the European Court of Human Rights case law, like any other search and seizure, since Nimitz versus Germany, which was kind of one of the first judgments of the court, it requires a judicial authorization, an adequate legal provision, legitimate aim, necessity, and obviously proportionality in the strict sense. However, in the abstract, these terms are quite well known. If we go to the details, what is exactly legitimate aim? Any kind of crime, regardless its the level of suspicion that law enforcement already has. Second, what is legal provision, detailed legal provision, to undertake a search of a law office. And when I say the search of a law office, I'm meaning also obviously the search and seizure of the electronic files. And there's two differentiations, or two levels to be differentiated. On one side, obviously, when the lawyer and the law firm are not suspects themselves. So in the general rule I've seen in all European countries is this search and seizure of a law firm that is not suspect in themselves is illegal. So that would be the way just to get information from the communications between their defendants, their clients. But if the firm is not a suspect themselves, such search and seizure is not authorized in all countries, in all legal systems within the European Union. However, what is seen in practice in some cases, in some countries, a certain abuse to indict the company or the law firm or one of the lawyers in order to access the files of the clients. And this has been dealt with by the European Court of Justice, by the European Court of Human Rights in several cases against Portugal. And so what has been agreed is that there needs to be not only an initial suspicion, what in German would be an Anfangsverdacht, but already a higher level of suspicion in order to carry out the entry and search in a law firm. Because at the end, if the if the level of suspicion is low, and even later at the stage of the criminal proceedings, the law firm or none of the lawyers is indicted, then the information is already in the hands of the pre-trial investigators. And this obviously circumvents their protection and is an absolute practice that should be absolutely avoided. What happens when the search of the law firm is legitimate? Because the lawyer in itself is a suspect. And in these cases, the main problems on protecting lawyer-client privilege arises first. The communications do not affect only the lawyer as defendant, but the other third parties, other clients, and other communications with the defendant or the other co-accused. What are the kind of elements that can be seized, or how to carry out the computer searches within a law firm in order to keep them proportionate? Because up to now, the general practice in those few cases where law firms have been searched, and their files, electronic files, have been searched, and there are several cases, it would sound that is a very rare or exceptional measure. It is, but taking into account the number, already quite a number of cases that have reached the European Court of Human Rights regarding disproportionate search and seizure of electronic files within law firms, I would say this is going an increasing practice. Obviously, mainly because, not only because many lawyers might be involved in money laundering and other illicit activities, and but also because law enforcement is discovering and taking into account that really a very, very important information can be found through these searches. And to that end, okay, the consequence of this disproportionate search and seizure, what would be inadmissibility of evidence? They take the risk. They don't want to use this as evidence, but they get all the information of network structure, organized crime, and money launderers through these disproportionate searches in some cases. So how to deal with them? And I'm just finishing my presentation. Holger, interrupt me if I'm too long. The case of Volant, I'm not sure if I'm pronouncing it correctly. Well, these are the requirements in search of seizure. There has to be a presence of an impartial witness, should be a representative of the Bar Association, and the lawyer who is under inspection under the search. And in order to make sure that only documents that are related to the investigation are to be seized, to protect third clients, third parties, and to leave out all kinds of other communications that are not dealing and have no relationship with the case under investigation. So you see, I put here several cases, two of them against Portugal, one of 2010 and the other also of 2015, where they used during the search of the computers within the law firm. It was a very, very, very serious, important case where it was dealing with a huge public investment, and Cérvulo and Associados were dealing with legal advice on that, and there was kind of suspicion of corruption of some public officers, but we're talking about a case of $1 million. So during the search of the computer, the law enforcement used 35 keywords. And among these keywords was kind of transaction. Can you imagine how many files you can access just by using the keyword transaction? So at the end, 89,000 electronic files were seized during this investigation. From our point of view, it would seem to be it's absolutely excessive, because at the end, only some hundreds of these files were used as evidence in the trial and were related to the case. However, this was not considered a violation of Article 3, even it was excessive, because there were enough safeguards in place, and judge was present. The filtering was done by a different judge, and so enough safeguards to prevent excessive, disproportionate search was in place. Please explain me, because I don't understand this. If the safeguards are to prevent disproportionate access to files, and the access to files is considered disproportionate enough, how can it not be really an infringement of Article 3? I leave you on the slides all the elements that the court has taken into account in order to find that the search and seizure in law premises and law firms has been considered and taken into account to assess violation of Article 8. And I'm coming very quickly, just the last case I wanted to present is Volland versus Norway, because it is kind of a new stage in requirements to the legislator, to the states, in order to prevent these breaches of the lawyer-client privilege by carrying out searches of computers and law firms. This judgment is not on so recent anymore, it's of 2018. And just very quickly, the facts. Why it's this case, and it came to my attention, and I think it's interesting to share with you, because it shows how some national systems regulate very clearly and very thoroughly the procedure to execute the measure of entry and search of a lawyer's office. And in this case, Mr. Volland's home and professional office, I'm finishing already, were searched. And he was charged of fraud and forgery. The court in this case does not assess whether the safeguards adopted in the execution of the search was sufficient or adequate, because with respect to this measure, the remedies available at the national level had not been exhausted. So this is not addressed. But this judgment is interesting because it shows that the safeguards, according to the Norwegian legislation, were adopted to guarantee the legal professional secrecy, especially that the paper documents that were seized were placed in sealed bags, these Faraday bags. The officers didn't examine these papers. Those files were protected by lawyer-client privilege, were referred directly to the court, so that the court could do the filtering of those data. And the same was done with the hard drive that was seized and the laptop that was seized. So after agreeing, the judge with the defendant on the keywords to be used in the search of the computer, the filtering was carried out by the IT department of the court. So we can say that the execution of the computer search provided sufficient measures to protect lawyer-client privilege. However, the court states, European Court of Human Rights states, that as long as these safeguards were not provided in the law, but were agreed and on the practical level, the convention is infringed. So this is a call and a warning for every country to say, please carry out your own protection at the safeguards and regulations at the legislative level, because otherwise the requirements of the convention will not be complied with. I'm finishing this presentation right now. I would go on Upjohn, a lawyer, and the control group who is protected in the communications between defense attorney within a company and so forth. I can come later if you have questions with regard to it.